It may be indicative of a reality that companies aren't doing enough to prevent this. I'm not a data security expert. I don't know. But I think it also may just be indicative of the fact that the sophistication of these hacks continues to rise. And, the hackers are getting more and more advanced, and even the best, biggest companies are having a hard time protecting themselves and their customers.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, TermScout founder and CEO Otto Hanson tears down the SolarWinds Software Services Agreement. This document has been in the news after a historic breach. But, as Otto points out, these software services agreements are often part of a complex web of contracts. Otto shares how to manage and examine complex software supply chain agreements quickly and how to avoid the risk that comes with them. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. On this show, we do exactly what it sounds like. We take documents, we beat them up, we insult them, occasionally say something nice. I hang out with smart friends like my buddy Otto over here to talk about the contract language. Otto, how are you doing today?
Hey Mike, I'm doing great. Thanks for having me.
I appreciate you being here. We're talking about this particular document that I want to share with you guys. It was in the news a little while ago. This is the Software Services Agreement from SolarWinds, and we're going to talk about why this document was in the news and what's relevant about it. But Otto, tell me about this kind of document. When are lawyers likely to encounter this kind of document? Why is this one representative of a choice that people are going to have to make in terms of software purchases? Why this document?
Yeah, so this is a standard click-through agreement that SolarWinds, as I understand it, asks most or all of their customers to sign when they start using SolarWinds Software Services. It's emblematic or representative of sort of where we are in commerce today, where it's one of thousands, maybe tens of thousands of software tools that big companies may embed in their supply chain, in their infrastructure, in their business. And it's just one of many click-through agreements that will determine the outcome of, typically what happens if something goes wrong in this relationship.
Yeah. And we'll talk about this particular experience. But before we do that, tell me about you. What's your background? When are you running into documents like this? Where's that insight coming from?
So I'm a corporate attorney by training, Mike, but I'm the founder and CEO of a company called TermScout, which is basically in the business of reviewing click-through agreements from B2B software companies and comparing them among their peers.
Very cool. So let's talk about this document, because I do think in some ways, like you said, it's representative of other documents, but in some ways it stands out. And before we get to that, let's talk a little bit about the background. You had mentioned that this software is one of many. There was a breach recently. We're not necessarily saying whose fault it is, but there was a breach recently that hit the news because it was huge. It was widespread. It went on for 8 months before people realized it was a thing. It affected, I think I saw 18,000 customers. This was a big breach. Many of those customers were government agencies, including really sensitive government agencies. And this breach, apparently perpetuated by Russian espionage, it was a big deal. And what I read that was unique about this, to get to your point, is that this was a supply chain breach because SolarWinds is one of like a bunch of softwares that a company will buy to accomplish an end result. And I think so far on this show, we've talked about documents with software companies that it's almost like, I'm purchasing this software, here's our contract. We talk about third parties in passing, but this is, you're buying a thing that is integrated into a larger ecosystem. How much attention are you paying to that? Before we get into the particular language, do you have anything to add to that sort of history and that background? Anything you want to add to that?
No, you summed it up nicely. And, it's worth pointing out that SolarWinds, we looked at SolarWinds contract. We don't know if SolarWinds was responsible or how culpable they are. And that's obviously, you and I won't opine on that. It's not our place to be. As far as we're concerned, innocent until proven guilty. But it's a name that keeps coming up in the context of this large data breach, historic data breach. And what I know is that technology leader friends of mine, CTOs, and legal leaders around the country are, as soon as this news broke, we're pulling out their SolarWinds contract and finding out, do we have a contract with SolarWinds? And if so, what does it say? And what are our rights if SolarWinds indeed, is found to be liable in some way or responsible in some way for this breach? So that's kind of the context that I think we're looking at this as a purely hypothetical situation, and sort of put ourselves in the shoes of, if I'm one of those technology leaders or attorneys in a company that's using SolarWinds and I'm pulling out this contract, what am I finding? And that's what we're going to answer today.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Yeah, so let's do that. We're going to jump, focusing on data and liability stuff, we're going to jump down to 7 in this document. In 7.1, it talks about your data. It says SolarWinds and affiliates can remove your data or any data if they find that it's at its sole discretion, if they find or believe it to be a virus, illegal, libelous, abusive, used for spamming, if it's infringing the intellectual rights of somebody else, and they can, let's see, if they're protecting backups of your data directly, they put some expectations on you. What do you think of this section? Do you think this is the right way to, sort of draw the line of responsibilities where data is concerned?
Look, I mean, I think there are some things we could nitpick one way or the other on 7.1, but I think what's interesting really is 7.2, which, 7.1 is all about what the customer's obligations are. And my hunch is, it probably isn't one of the major provisions coming into play in the analysis under this hypothetical scenario. But if you get to 7.2, that's where we're learning, what did SolarWinds commit to doing to protect the customer's data and the customer's infrastructure and systems? And that's where, you start to see in sentence 2, each party shall maintain appropriate administrative, physical, technical, and organizational measures that ensure an appropriate level of security of confidential information and personal data. This is sort of kind of the table stakes data security promise that a lot of companies make. It's good. If I'm a customer, I want to see this. It's also somewhat vague. What is an appropriate administrative measure? What is an appropriate physical measure, an appropriate technical measure? So it's not a slam dunk if I'm a customer, but it is something, and it's more than a lot of customers or a lot of vendors actually commit to. So when I looked at this, I was actually pleasantly surprised, and I thought, gosh, if I'm a customer, all right, chalk up a point in the win column. We've got a commitment that they were going to make, take appropriate measures. I don't know if they did or did not, but at least I've got a pretty decent commitment here to start with.
Well, and what's fascinating is the company that discovered this breach, FireEye, the reason that they found it 8 months into the breach was that one of their people, one of their customers, had two-factor authentication. And so they went in and they got this ping in their email that says, hey man, somebody's trying to do this, get into your account. And they didn't say yes to it. So they're doing some of these standard, best practices, prevention stuff. And that's actually how they discovered it. But the fact that it took 8 months for somebody to have what we now would consider a pretty basic level security tells me that a lot of people probably were not, paying attention to this section. Just fascinating that it took that long.
It is. And it's, it may be indicative of a reality that companies aren't doing enough to prevent this. I'm not a data security expert. I don't know. But I think it also may just be indicative of the fact that the sophistication of these hacks continues to rise. And, the hackers are getting more and more advanced. And even the best, biggest companies are having a hard time protecting themselves and their customers from the level of risk and the types of attacks that we're seeing today. So it's a really challenging environment, and it's a tough spot for both vendors, software vendors, and their customers to try to figure out. So, to wrap up 7.2, there's one more commitment in 7.2, which is the third sentence, which says SolarWinds Worldwide and its affiliates will process personal data in accordance with the data processing addendum. That, I consider that to be an incorporation by reference, which means that SolarWinds is basically, they've got this data protection addendum, a DPA, that outlays a number of additional technical organizational measures that they take to protect personal data. All of it wraps up, in my opinion, when I looked at this contract, I kind of came out and said, you know what? SolarWinds has done a pretty good job of making, they made pretty decent commitments to protect the data of their customers. I felt pretty good when I got here. But what we'll learn, I think, if we jump into section 11, is it now a good time to go there?
Yeah, let's do that. 11 talks about the limitation of liability. Go on. We'll talk about that section.
So this is really where I think the rubber hits the road. A contract is, there's, I think, two foundational or fundamental parts of a contract. What obligations or commitments does each party commit to? And if those go wrong, what are the remedies available to the other party who didn't get the benefit of what they bargained for in the contract? So here, on the one hand, we just saw that, SolarWinds makes some pretty decent data security commitments. And now when we get to section 11, what we see is that basically they've gone and said there's really two elements to section 11. The first sentence, which in true lawyer fashion here is a whopping, I can't even count, 9, 10 lines long.
Right.
Is the waiver of indirect damages. And what this one says is, to the extent permitted by applicable law, and that, by the way, may vary in different jurisdictions. But basically what it says is SolarWinds will not be liable for indirect, consequential, punitive, those types of damages. Basically, it says, unless the damages are direct, you cannot recover from us. This one is relevant in a data breach scenario because much of the damages, presumably, that the customer suffers would likely be categorized, I think, as indirect or consequential damages. I'm not a litigator, but my understanding is a lot of those damages are harms to third parties, as you pointed out earlier, and all the different sort of types of consequential damages that trickle down as something like this and the consequences unfold. So what constitutes direct damages could, in reality, be a relatively small portion of the overall damages. So right here in this first part of section 11, you basically are hearing from SolarWinds, hey, yeah, we've made these nice commitments, but to the extent that we fail to honor them and you're damaged, we're immediately limiting to direct damages. Pretty common thing to do, by the way, actually very common. In fact, out of 327 contracts, similar B2B software contracts that we've reviewed at TermScout, every single one waives some form of indirect damages. And then the second part that you have in this section is the cap, what we call the cap on liability, which is SolarWinds has capped its liability to 12 months fees. This is also very common. This is the most, this is market. I think out of 327 contracts, it's something like 180, like 60% limit their liability to 12 months fees. But what's interesting about this limitation of liability provision is there are no exceptions to either the waiver of indirect damages or the cap on damages. So basically, I think when you come to section 11, you're starting to get the picture as a customer that, okay, even though we have these pretty good commitments in the data security section, it's not clear whether I'll be able to recover much more than my 12 months fees. Right. And even the 12 months fees, I have to show that they're direct in order to get those back. So it's, if I'm a customer and I'm pulling this out and, I've been affected by this breach, I'm pulling this out and looking at it. Now I'm starting to chalk some points out in the, oh boy, this is bad news column.
Yeah. And as we talk about these contracts, especially because this is a newsy moment, there's a story behind it, people are paying attention to it. I'm thinking about principles, about sort of the big picture, and I'm thinking of this in two ways. One as the drafter, and one as somebody who's in-house who's doing some advice. As a drafter, is there a principle from the fact that this, to say to the drafter, look, dude, this is one of many contracts that a user, the end user is going to be looking at in terms of being able to actually execute on this software, to actually be able to use this thing. Is there a principle from this conversation about liability and the relationships between all these different vendors that we can pull from as drafters, some way that we can draft in a way that recognizes that context?
Yeah, I think there is. And first, there's sort of, I think, just a recognition that has to happen, which most drafters have already, gotten to, which is this is a really big friction point between the vendor and the customer. Because as a vendor, if I'm drafting this for a vendor, I don't want to take any more liability for this. I mean, this is, if in SolarWinds defense, if they took unlimited liability for data breach claims and they had hundreds or thousands of customers coming after them with uncapped liability, they would be looking at a bankruptcy proceeding almost certainly. And that might not be good for anybody either. It could be really hard for vendors to raise money if they accept uncapped liability for, in particular, this type of liability that's very hard to fully protect or insure against. So that's the vendor's position is, I can't, it's just not possible for me to take unlimited liability. But the customer's perspective is at perfect odds with that, because what they're saying is, look, if I'm using your software, embedding it in my supply chain, why should I bear the risk of if you let the hacker in or if something happens there? So you have this really intense friction to just recognize and accept as a drafter. The principle in my mind is it depends on the company you're drafting for, but if you expect your customers to have leverage or to come back and negotiate, it might make sense to craft or draft your contract up front to, recognize and understand that this is likely to be an issue that they're going to be asking for, and see if you can go out of your way to make the limit of liability provision a little more generous. You're probably not going to accept all liability for data breach type issues. But what we are seeing is a number of companies. Right now, there are 7 of the 327 that we've reviewed at TermScout who, in their standard click-through agreement, are offering a secondary cap that covers data breach claims. Among those companies is Snowflake, for example, the big cloud company. And what theirs says is, hey, if there's a data breach claim, we'll actually accept 2 times liability for those types of claims. So it's 2x the normal cap. So they haven't gone all the way to unlimited liability, but they have accepted more. And my hunch on why they did that is they were probably seeing a lot of customers coming back saying, we want unlimited liability. And them saying, no, it's capped at 12 months. And they were landing at this secondary cap, which is the middle ground. And they just said, they made the business decision to say, let's offer it to everybody. It's the customer-friendly thing to do. And it should help us avoid negotiating this same provision over and over and over again.
Right. I think we all know that direct liability is sort of laughable in terms of these kinds of breaches, these kinds of harms. And so I like that as sort of a middle ground. But, I feel like this fight is going to go on as long as we have computers. I'm also thinking in terms of principles on the other side, and maybe this is getting to tell us a bit about TermScout, because I'm thinking of the lawyer who's in-house. And again, this is a supply chain breach, meaning there are a ton of softwares that are strung together, and one of them can be the point of vulnerability at which a ton blows up. And so we're in the end sort of looking at, let's say, 15 different contracts. We're signing off on all of them. We're supposed to review and understand every one of them. It becomes this very complicated web, how these different softwares work together. Talk to me about a principle there and maybe how TermScout can help people sort of speed up that process of evaluation and raise red flags where they're there.
Yeah, well, you're right. It is a huge problem. If you're signing large volumes of these contracts, as larger companies are, it's just untenable to think that you can review all of them thoroughly, understand all the risks. Many of them aren't negotiating these terms, often no matter how big you are, but certainly only if you are quite large of a customer. So you have this predicament of, an onslaught of vendor contracts that you have to sign. which do embody a fair amount of risk, especially to the extent that those software applications are touching my data in some way. TermScout is one solution. We built our company to solve for this problem, basically. And what we're doing is reviewing those standard click-through agreements of big companies. And we've reviewed 327 of them to date. They're published on our website. You can go to termscout.com and see free ratings on all of them. We use human attorneys to do this work, a combination of natural language processing, artificial intelligence, and human learning attorneys. Right. But the human attorney element actually is, making sure that there's pretty high quality on this review, because we know that if you're going to substitute a third-party tool to do this red flag screening for you, it's hard to trust pure eye solutions. When I was working as an attorney, I couldn't trust pure eye solutions. I tried them, and there were a lot of false negatives and false positives, and that actually made my work harder to sift through all that. So, that's one solution. There are a number of software solutions that do try to help screen for these risks too. But the short answer, the principle, I think, is as a company, you've got to get sophisticated. You've got to get digital. You've got to find tools that can help your limited resources do more with less.
Yeah. I think if this episode can do anything for you guys, it would be to raise the red flag of the complexity of these contracts. I mean, this, but tools like Law Insider in the drafting side, like what TermScout does on the evaluation side. I mean, these tools are so important for being able to improve this ecosystem of contract drafting and evaluation, which in this world of complexity is so important, as this TermScout example shows us. So I appreciate you hanging out with us and tearing this down with us, Otto. If people want to get in touch with you to learn more about what TermScout does and how you're looking through documents like this, what's the best way they could reach out to you?
Yeah, visit us at www.termscout.com or email me at Otto at termscout.com.
Perfect. And you guys, we will have his information, Otto's information, as well as a link to this document and relevant pieces of information over at TermScout at lawinsider.com/resources. Just look for the show notes on that. Also, if you want to be a guest on the Contract Teardown Show and beat one of these documents up, just email us. We're at community@lawinsider.com. Otto, thank you again. We'll see you guys at the next episode.
Thanks, Mike.